All right, now we're recording. Hey, it's Jocelyn Jean-Louis Hardrick here with Journey to Esquire. We have another fabulous CLE for you all. Journey to Esquire, we create lawyers who lead, mentor, and inspire one student at a time. And we do that through curated conversations, personalized preparation, and meaningful mentorship. And as part of our CLE lineup, I have this great speaker, Natalie Jean-Baptiste. Natalie and I go back all the way to college. And we went to law school at different times and in different places, but we reconnected a while ago. And I knew she was doing a lot of work around bankruptcy discharge, specifically for student loans. And she was one of the people to be a pioneer in getting some of these student loans discharged, because that was the whole thing when we went to law school, right? They said, oh no, you can't get student loans discharged. Well, that has changed a lot since Natalie and I have graduated and since she's done a lot of this work. So let me let you know a little bit about Natalie, and I'm going to pass it to her. Natalie Jean-Baptiste is a staff attorney at the Legal Aid Society in New York City, where she represents debtors in Chapter 7 and Chapter 13 bankruptcy proceedings. She is dedicated to helping low-income New Yorkers resolve their debt problems and get a financial fresh start. That is the key word when you're talking about bankruptcy. Natalie joined the Legal Aid Society after a decade in private practice, where she specialized in consumer bankruptcy and student debt relief. She's especially committed to economic empowerment and advocacy for student loan borrowers, and she has had a lot of success with discharging student debt in bankruptcy, which is notoriously difficult to do. Like I was saying earlier, before she had her own practice, she also worked many years in the music industry. She handled contracts for superstar acts like Alicia Keys and Janet Jackson, and her own personal struggle with student loan debt led her to become a bankruptcy attorney. And now she's also a lecturer in law at Columbia Law School, where she teaches a consumer bankruptcy externship course. She and I earned her bachelor's from Fordham University, and she got her JD from New York Law School. She's admitted to practice law in New York and in the federal courts, U.S. District Court, Eastern District of New York, and Southern District of New York. Welcome, Natalie.
Thank you. Thank you so much for having me. I'm so excited to talk to your students and your audience about this topic. And it's especially, close to home for many of us who have massive student loan debt, right? So, thank you for the introduction. Before I get into like the heart of the material, I want to share a little bit more about my story and how I got to be an expert in student loan debt and bankruptcy. So, about a decade out of law school, I saw myself still struggling with massive student loan debt along with other consumer debt. And I was at the point where I decided I needed to file for bankruptcy. And at this point, I had consulted with a few attorneys who, their fees were pretty high and I didn't have enough money saved up. And of course, they all told me I can't discharge my student loan debt. And I had made peace with that. I said, okay, fine, I can't get rid of the student loans, but I'll get rid of my other debt and that'll make these student loans easier to manage. Um, I was stressed out about finding a lawyer, and my boyfriend at the time, he just didn't understand why I was stressed about finding a lawyer when I was a lawyer. He's like, "Aren't you a lawyer? Why can't you just do your own bankruptcy?" I'm like, "That's insane. Like, would you want a heart surgeon operating on your brain? Of course they're smart, but they don't know about the brain. They're a heart surgeon." But he's like, "Well, it's not life and death, just," and he made very light of it, and I was annoyed at first. And then I decided to teach myself bankruptcy law. And as I was learning bankruptcy, I discovered something called the undue hardship exception. The stuff that nobody tells you about, meaning, yes, the general rule is you cannot discharge student loans in bankruptcy, but there's an exception for something called undue hardship. And I'll get into, what undue hardship means in the slide, when get to the presentation. But long story short, I was able to bring something called an adversary proceeding and prove undue hardship. And, a few weeks before trial, I was able to settle my $156,000 student loan for $36,000. So through this process, I effectively wiped out $120K of my student loan debt. And I was blown away because like I was so naive that I thought it was possible, right? But seasoned bankruptcy attorneys were like, oh, like who does this girl think she is? Like you can't get rid of student loans. Like what is she doing? And they would stop and be like, sweetie, you're wasting your time. It's not like it's impossible. And I was like, what is the problem? Like why? I felt like I was in the Twilight Zone. So anyway, after my success, I said, I want to do this for other people. Like, I want other people to have the possibility of being free in general. Like, I fell in love with bankruptcy law, but specifically to advocate for student loan borrowers. And I've been doing it ever since. I was in private practice for a long time, for almost a decade before I transitioned to the Legal Aid Society. But and initially I was like, oh, maybe my case was a fluke. Maybe I can't do this for other people. Maybe I'm just lucky. But nope. Like I've had a few losses, but overall, I was able to get discharges and partial discharges for most of my clients through this process. Okay, so now we're going to get into the material. So just to do a brief overview of what we're going to cover today, first we're going to talk about bankruptcy basics for those people who have no background in bankruptcy law. Then I'll talk about Section 523A8, which is the part of the bankruptcy code that covers the dischargeability of student loan debt. Then I'll talk about what a qualified education loan is, and this is relevant for private student loans. Then the heart of the presentation will be establishing undue hardship. And that's the argument that most clients who are seeking to discharge their student loans will make. Then I'll go over drafting the pleadings and discovery, like the litigation aspect of it. Then I'll touch on student loans in Chapter 13. And last but not least, I'll cover the new DOJ guidance on the discharge of federal student loans. Okay. So before I get into the law, just to give you some background and facts and figures. So student loan debt is at $1.75 trillion in America. 45 million Americans have student loan debt. So that's 1 in 5 adults have student loans. And 92% of it is federal, the rest is private. So one thing to establish initially when you're analyzing a case is to figure out whether the student loan is federal or private because they're treated very differently. So first of all, the interest rates are very different. They're much lower with federal student loans. They're between 4 and 8%, roughly. And then for private student loans, it can be as high as 20%. Federal loans have flexible repayment options and loan forgiveness, while private loans do not. Federal loans also have serious default consequences, like the wages can be garnished without a court order. Um, the tax refunds can be intercepted, things like that. But the private lender has to sue the debtor first and win a judgment in order to be able to collect anything. Federal student loans have no statute of limitations. So they can follow the borrower to the grave. Private loans, on the other hand, depending on which state you live in, the statute of limitations governs how long the creditor can collect. So in New York, that time frame is 3 years. So if more than 3 years have passed since the last payment was made, then the claim is time barred. I'm not sure off the top of my head what it is in Florida, but you can look that up easily. Federal loans are not tied to credit worthiness. There's no cosigner required. Private student loans, on the other hand, typically there is someone who has co-signed a friend or family member. a parent, usually a parent, but sometimes a grandparent, an uncle, somebody who co-signed the debt. Okay, so first, in order to figure out what type of loan it is, you can go to studentaid.gov, and that's the federal student loan database that houses all the information regarding federal student loans. The person needs an FSA ID, and they're going to log in, and this is the account dashboard. This is where they can see all the details of the loan, and there's also a report that looks the breakdown of when the loans were dispersed, what schools they went to, things like that. So all of this is available on studentaid.gov. If the loan is not on studentaid.gov, if it's not in that database, likely it's a private loan. And there they can pull and find that information on their credit report. And they can get their credit reports from each of the bureaus at annualcreditreport.com. Okay, so now I'm going to get into the basics of bankruptcy just to establish, because that's always the first step, is to file bankruptcy before you can move on to litigating the student loan debt. So bankruptcy is a legal process established under federal law to allow people who cannot pay their debts to eliminate or discharge the legal obligation to pay most or all of certain types of consumer and business debts and obtain a financial fresh start. Okay, so the foundation of this is in the Constitution. Article 1, Section 8 of the U.S. Constitution authorizes Congress to establish uniform laws on the subject of bankruptcies throughout the U.S. Under this grant of authority, Congress enacted the Bankruptcy Code in 1978. Again, the fundamental goal of bankruptcy laws is to give debtors a financial fresh start. Okay, so bankruptcy is a court of equity, so keep that in mind. So not only is it looking to give a fresh start to debtors, it also requires a fair distribution to creditors. When there are assets that can be liquidated and things that can be paid out, all the similarly situated creditors need to be treated fairly.
Okay, are we gonna go into what's assets, what's liquidation? Some folks will be like, what are assets? What is
Right.
what? I remember when I first heard liquidate, I'm like, it's gonna turn liquid? What?
Right.
And then what the other thing I want to know before you move on, because we talked about, you mentioned co-signers. Do they are they a part of this process, or do they have to do this separately? This is not done together with your co-signer if there's an issue, right?
No, there's not. And I'll touch on that when I cover Chapter 13 bankruptcies, because Chapter 13 specifically protects co-signers. But just to give you a background, like just on basics of bankruptcy, assets is the person's property, right? So their bank account and their house and their car and even just regular things like clothing, jewelry, stuff like that. But what people don't understand, or a lot of misconception about bankruptcy, is that you can't have anything, and that's not true, because the assets are covered by exemptions. So most cases, every asset that the debtor has is exempt, meaning that the creditors can't touch it. No, the trustee can't touch it. So it's not subject to liquidation. So liquidation is when you basically, the property is sold off to pay creditors, essentially. But most of our clients, especially with legal aid, there are no assets to liquidate. So they're called no asset cases, but that does not mean the person has no assets. For example, the homestead exemption in New York City is nearly $200,000 per debtor, right? So they can have that much equity in their home and still keep their home and discharge their debt, right? And I'm not sure what it is in Florida, but actually, Florida has an unlimited homestead, and Texas has an unlimited homestead for bankruptcy. So that's pretty amazing. Like, it's one of the few states where your home could be worth $1 million and you still discharge your debt. So anyway, all right, so back to the slides. So this quote from a 1934 Supreme Court decision sums up nicely what bankruptcy is about. Bankruptcy gives the honest but unfortunate debtor a new opportunity in life and clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. And I think this is especially relevant for student loan borrowers, right? Because they took on this debt hoping that it would open doors for them, and many times it's just hindering them more than it's helping them. And so many people have the debt without the degree, and they really do need a fresh start and need to be able to move on with their lives and just have, a clear field to move on. So the goal of bankruptcy is accomplished through a discharge, and it releases debtors from personal liability from specific debts, and it prohibits creditors from ever taking action against the debtor to collect those debts. The debtor is no longer legally obligated to pay any debts that are discharged, right? So the types of personal bankruptcy, there are two types. Chapter 7 gives the debtor a discharge for most unsecured debt, the liquidation plan in which non-exempt assets are used to satisfy what's owed to creditors. Like I said, most Chapter 7 cases are no asset cases, meaning that the debtor's property is protected from the creditor's claims. Chapter 13 is also known as a wage earner's bankruptcy. The debtor has to have regular income to repay some portion of their debt through a court-approved plan within 3 to 5 years. So the debtor keeps all their property, including non-exempt assets. So the automatic stay is one of the beauties of bankruptcy. It stops all collection efforts, right? So that includes collection calls and letters, any lawsuits, wage garnishments, foreclosures, repossessions, and it has to stop immediately. Literally, the second the case is filed, even if the case is filed at 11:59 and the foreclosure sale was scheduled for noon, that foreclosure sale cannot move forward. And if it does, then it's voided. Okay, so I want to distinguish between dischargeable and non-dischargeable debts. So dischargeable debts is what we all generally think of when we think of debt. Credit card debt, medical bills, personal loans, auto loans, payday loans. Non-dischargeable debts are debts that get special treatment, right? So taxes, well, for public policy reasons, or because the creditor is deemed more worthy, right? So taxes, child support and alimony, fines and penalties owed to the government, DUI debts, so any debts that are related to drunk driving accidents. And then student loans are also part of that category. Okay, so chapter 20 is a sort of a made-up term for student loan attorneys who do like a step 1, step 2 process. So first, to file the chapter 7 to discharge all of the dischargeable debt, and then step 2, file the chapter 13 to manage the non-dischargeable debt like taxes, student loans, child support, things like that. So this is a good strategy for if the person doesn't qualify for an undue hardship discharge or can't afford to go through the adversary proceeding, chapter 13 is still a good way to manage the debt. Okay, so now we're going to get into section 523A8, which is the section of the bankruptcy code that discusses the dischargeability of student loan debt. Okay, so basically it's restricting the dischargeability of student loans for any debt that's deemed from a governmental unit or nonprofit institution, and it's an educational benefit, scholarship, or stipend. And then Section B covers private loans, so basically any other educational loan that is a qualified loan as defined in the Internal Revenue Code of 1986. So I will discuss what that means and what a qualified loan means. Okay, so the legislative intent of 523A8 was to prevent undeserving debtors from abusing the educational loan programs by declaring bankruptcy immediately after graduating. So they put this in place more as a preventative measure, not that there was any evidence that this was actually happening. Maybe this was a handful of cases, but it wasn't like a problem. It was just something they thought of, like they don't want people to go, to med school and law school and then just run to bankruptcy court and discharge their debt. The other intent is to preserve the financial integrity of the student loan program, which I always say the student loan program lost its integrity a long time ago. Like it has spiraled to something that's unrecognizable from what it was originally intended to do. Okay.
Well, hold on. You can't just say that.
No,
let's go in
because
that up.
yeah,
Yeah, a
so
little bit, because I know there's one of the big debates now is student loan forgiveness, right? Because I talk
mhm.
about it with my students, and there's really divided. Even though they're students, they're like, "No, you took it out, you should pay it." And other people like, "Well, there's all these circumstances that happen." And with the Biden administration, that was one of his promises. So, and it went up to the Supreme Court, et cetera, et cetera. So let's go back a little bit to your statement about it is already spiraled and it's unrecognizable now. Tell us a little bit about what was it before
Right.
and why, you made that
Yeah.
statement.
So, I mean, originally when it was the Higher Education Act of 1965 was to give everyone access to education, and just put everyone on equal footing. And back then, college was affordable. Like it was, you could pay your college tuition by working a summer job, like literally. And, over the course of the years, and particularly the late 90s, early 2000s is when it started to spiral out of control, where the cost of tuition kept rising and people were taking on more debt it was just like a catch-22. Like they raised the tuition because students are taking out money. And if you read the stats, first of all, it's impacting people of color the most, it's impacting women the most. And a lot of times people have these degrees and they're not even able to climb the ranks and open the doors that they thought they could. These colleges are building fancy resorts, right? With the money that these students took on the debt to pay for. Um, and the college presidents, I read a stat a while ago, and I need to find out exactly what the source is. It was in one of the books I was reading that, dozens of college presidents make over $1 million a year. Like that's their salary, right? And meanwhile, all these students are in debt. So the original intent was to give people access to education and make it more affordable and give them like, a leg up in life. And now it's just turned into a burden and something that actually is to their detriment and holds them back. So that's the long and short of it. So back to the slides. So in order to discharge a student loan, it's not as simple as just listing it in your bankruptcy schedules. It does require litigation and it requires the debtor to file something called an adversary proceeding, right? And, when student loans are being litigated, the court has the power to enter the final judgments regarding the dischargeability, right? And under Rule 407, B 4007B, the debtor can file a complaint at any time. So it permits the debtor to reopen a closed bankruptcy case to file an adversary proceeding without paying an additional fee. So they file a motion to reopen the case. So I've had many cases where a debtor will come to me years after they had already filed bankruptcy, and they used another attorney who told them that their student loan debt was not dischargeable. And then they hear about me and they say, "Can you help me?" And then at that point, I file a motion to reopen the case. And then once the court grants the motion, then I file the complaint regarding the student loans. Right, so just to be clear, so the adversary proceeding is a lawsuit where the borrower is the plaintiff and the lender, and usually it's the United States government, and then additional borrowers like private banks, they are the defendants, right? So when you're drafting the pleadings, it's important to identify the right defendants because student loans often change hands and servicers. So doing the research to find out which bank owns it, or is it a federal loan or a private loan? So the stuff I talked about in the beginning is important to distinguish who the defendants are. Right, so a direct loan is going to be held by the United States Department of Education. An FFEL loan, which they stopped issuing a while ago, but anyone who went to school in the 90s and early 2000s may have something called the FFEL loan, which is the Federal Family Education Loan Program. And those are held by guarantee agencies like ECMC, which stands for Educational Credit Management Corporation. So when you're drafting the pleadings, you would name the Department of Education. That's what ED stands for. Department of Education, the current servicer, and any guarantee agency as a defendant. And again, when you're doing the research, you can go to studentaid.gov to figure out who holds the loans, and private student loans, you can find it on the credit report. So it's important that the summons and complaint gets served on all the defendants. So if the US government is a defendant, so if it's the US Department of Education, you have to serve the US Attorney General's office, the Department of Education, and the US Attorney's office in your district. So for me, I'm practicing in the Southern and Eastern districts of New York. So depending on where the case is filed, I would make sure to serve the U.S. Attorney's office in my district.
Yeah, it's interesting because the Southern and the Eastern are like right next to each other, right? Because
I
Brooklyn
know,
is
like
Eastern.
you could have a case in Lower Manhattan and then take the train 2 stops and be in Brooklyn and be in the Eastern District. It's just very,
Yeah, but that's how big New York is. But yeah, in
yeah.
Florida, we have the northern, the middle, and the southern, but the
Mhm.
middle includes Jacksonville, which is North Florida, and it goes all the way down to Fort Myers, which is near South Florida. So there's weird
Wow.
things about that. But that's interesting because that's a lot of people to serve. That can get
Right.
expensive. Even though you didn't pay the fee to reopen the case. Is there a complaint fee or is it just this process serving?
Well, the complaint fee is waived because if the debtor is the plaintiff, then they don't have to pay a fee to file a complaint. So, and then of course, I guess the cost of the postage for certified mail, things like that, but that's minimal compared to the amount of debt they're about to save. So. All right, so I'll get into what a qualified education loan is, and this is relevant to the private student loans because, obviously the federal loans are qualified loans. You can't debate whether or not they're legitimate. So a qualified loan is a debt incurred solely to pay for qualified higher education expenses at an accredited institution by an eligible student. So all three of those factors have to be present in order for it to be a qualified loan. Okay, so to find out what's going on, you can check the debtor's school against the U.S. Department of Education's Title IV eligible school list for the year that they attended. And if the school does not appear on the list, it's not Title IV eligible, and the loan could not be a qualified loan. Okay, so these are some examples of ineligible schools. So foreign medical schools are often not accredited. A flight school. So in this case, the Adams case, the debtor borrowed money to attend Desert Sun Helicopter Academy, which is not an eligible institution, and therefore the loan was dischargeable. Bar study loans. So this is an Eastern District case where the judge deemed that bar study loans are not an educational benefit within the meaning of the statute and is not a qualified loan, so therefore dischargeable.
So
So
that
an
means, just to
eligible,
clarify, that means those are dischargeable under the regular Chapter 7 or 13, and it's
yes,
not going to
yes,
satisfy the undue hardship we're trying to do here.
right. So basically, I mean, now it's well established, but back then, um, a person would get their discharge and then the bar study loan people would still be sending them bills, right?
Okay.
And then they would have to litigate whether or not this is a student loan. But now, I mean, that case is of at least it's going on a decade, perhaps, how old that case is, the Campbell case that's an Eastern District case. Um, Now it's pretty well established that bar study loans are dischargeable, so it should not require litigation, and essentially it would be a violation of the automatic stay for the bar study people to send the person a bill after they got a general discharge. Okay. All right, so back to eligible student is a U.S. citizen or permanent resident who's enrolled at least half-time, and they have to be registered with the Selective Service for males 18 to 25, and they need to have a high school diploma or GED or pass approved ability to benefit tests. So there are a lot of trade schools out there who enrolled people and they didn't have a high school diploma or GED and they didn't pass the required tests and they're in debt and they don't have a certificate or they have a useless certificate. So in situations like that, then the loan would be dischargeable. Okay, so just honing in on the definition of what a qualified education loan is. In order to be considered a qualified education loan, the debt must be incurred solely to pay for qualified higher education expenses. So qualified higher education expenses include tuition and certain related expenses required for enrollment in a course at an eligible institution. So related expenses, student activity fees and expenses for course-related books and supplies are included only if the expenses must be paid to the institution for enrollment or attendance. Okay, so when it's a private loan, the initial burden is on the creditor to establish that the debt is an educational loan and falls within 523A8. So it's not up to the debtor to prove that it's not a qualified loan. The creditor has to prove that it is, right? And they're the ones who have to bring in certifications and documentation showing that all three of those factors, it's an eligible student at an eligible institution, things like that. So just two examples where it's not a qualified loan would be debts incurred for housing, transportation, or living expenses to support full-time attendance, right? So those funds were not employed for educational purpose. Unpaid tuition is not considered an educational loan and therefore not accepted from discharge. I can't stress this enough because so many people have unpaid balances to their school. That is not a loan, it's just a balance. And their transcripts are being withheld. They can't move on to like try to enroll in another school or, even get a job, even if they didn't finish their degree, but to show that they went there. So again, this does not require litigation. So unpaid tuition, if it's listed on bankruptcy papers, is discharged automatically and does not have to be, they don't have to show hardship or anything like that. Okay, so cost of attendance, this is an important definition. It defines higher education expenses as cost of attendance. And the cost of attendance is determined by the school, and it includes tuition, books, room, and board, right? So the lender has to obtain school certification, and any amount lent in excess is not a qualified educational expense. So every year, each school publishes their cost of attendance for those semesters. And if you research and the debtor's attorney can subpoena the school as well to get the records about the certification, about what the cost of attendance was for that year, etc., to establish that the loan exceeded the cost of attendance. Okay, so these are some more examples of quote unquote student debt that is dischargeable. So again, unpaid balances owed directly to the school, credit card debt incurred by students, home equity lines of credit and mortgage refinance proceeds incurred to pay the cost of education. So some parents will refinance their house in order to send their kids to school. That is not a student loan, and that can be discharged in bankruptcy. Loans for unaccredited programs, again, like bar exam courses. Some parents take out money to send their kids to boarding school. If it's K through 12, it is not a qualified loan and therefore dischargeable. Overseas schools that are not accredited. There are a handful of schools overseas that are, but generally speaking, overseas schools are not accredited, and the loans incurred to go to those institutions would be dischargeable. Okay, so when you're drafting the complaint, if there's any question as to whether or not the loan is a qualified education loan, do not plead facts that admit that the loan is subject to 523A8. And on Schedule EF, that's where all the debts are listed. There's an option to check the box for student loan. If you're going to allege that it's not a student loan, do not check that box. Just leave it like it would be a credit card debt. Just leave it blank. Okay, so now here's the heart of the argument for most student loan borrowers, which is establishing undue hardship. The Brunner test is the majority rule. It's the rule in Florida, it's the rule in New York, and really adopted by all circuits except the First and Eighth Circuits. The burden of proof is on the debtor to establish undue hardship by preponderance of the evidence. So there are three things that the court looks at under the Brunner test. A, the debtor cannot, based on their current income and expenses, maintain a minimal standard of living for themselves and their dependents if forced to repay the loans. Two, that additional circumstances exist indicating that the state of affairs is likely to persist for a significant portion of the repayment period. And three, that the debtor has made good faith efforts to repay the loans. The totality of the circumstances test is minority rule. It's adopted by the Eighth Circuit and some courts in the First Circuit. So the three factors are the debtor's past, present, and reasonably reliable financial resources. Number two, a calculation of the debtor's and her dependents' reasonable and necessary living expenses. And three, any other relevant facts and circumstances surrounding each particular case. So now I'm just gonna dive in a little deeper to the Brunner test, which is the majority rule and the rule that most of you would have to use if you were to litigate in this area. So the minimal standard of living. So you look at, are the debtor's expenses reasonable, right? And are there any unique circumstances, like if they have a child with a special condition or anything like that? So the Ivory case basically spells out what a minimal standard of living is. So that includes decent shelter and utilities, food and personal products, vehicles maintained, insured, and tagged, health insurance or ability to pay for medical and dental expenses when they arise, at least a small amount of life insurance, and funds for recreation, like a cable or having a pet, for example. So this is what the court deems, you know, a minimal standard, like at minimum, the debtor has to have these things. And so many people, life insurance, for example, have been paying their student loans for years and don't even have life insurance. And they have, kids to look after, right? So they have 3 kids, they're paying Sally Mae, and they have no life insurance. That makes no sense. And even the bankruptcy court recognizes that. Again, just a list of reasonable and necessary expenses: food, housing, utilities, basic communication, necessary medical and dental, necessary insurance, transportation, childcare, child support, and alimony. What the court deems luxuries, and this has come up a lot, especially pre the new guidance, dining out, even if the debtor is going to McDonald's or Chipotle, they look at that as a luxury, like they should be cooking at home. A gym membership, premium cable, premium cell phone service, any type of salon, spa, cosmetics, so trips to Sephora, highly scrutinized. Concert tickets, like so any Ticketmaster, things that show up on the bank statement are going to be questioned and looked at as luxury, like luxury living, right? Any travel, so vacations, any expenses on alcohol and cigarettes, also looked at as luxuries, disposable income that could be used to pay the debtor's student loan. Okay, so the second prong of the Brunner test is the additional circumstances. So, are there additional circumstances that more likely than not, the current hardship will continue? And there's language from a 2009 case that where the judge says, you have to prove a certainty of hopelessness. There has to be a certainty of hopelessness for the debtor to get their student loan debt discharge. And it's like, well, how can you prove that? That's like nobody has a crystal ball. Like like prior to the new guidance being issued, like it was so ridiculous the way they treated student loans and how you basically like the way they made it seem is like you pretty much have to have one foot in degree in order to be able to get a discharge, which is insane. So the second problem looks at how long the hardship is likely to continue, and we're looking at the original loan payment, right? Not for 25 years or until the borrower dies. Again, the new guidance sort of like throws all this out the window. It makes it very clear, and I'll get to those steps in a minute. So good faith. So basically, when the court is looking at good faith, they're looking at the debtor's efforts to maximize their income, right? So this can be bad for people who decided to go on a different path, right? Like become a minister or artists and musicians, attorneys who decide to pursue public interest rather than go for the big corporate job. So they look at that as well. Are you doing your best to maximize your income? Again, prior to the new rules. Now they don't play around like that. Also in the Mosley case, the judge said that being too poor to make payments is not bad faith. You have clients who literally have never made a payment, but that does not mean that they, don't have good faith efforts because it was their intention to pay it. They're trying their best. They just literally don't have the means to be able to pay it. Now, I just want to touch on discovery and just the nitty gritty of the litigation. So this is what you can expect as a debtor's attorney, a plaintiff's attorney to receive from the lenders. They're going to send over requests for production of documents, including all financial records. So that would be tax returns, pay stubs, bank statements, retirement account statements, things like that. Employment records and proof of debtor's efforts to find work, medical records if there's a medical issue involved for either the debtor or the debtor's dependents, or if even so it would be the debtor or the debtor's dependents. They would request the medical records. Proof of expenses, so copies of their monthly bills to show how much they're paying on their car note, their car insurance, life insurance, health insurance, things like that. There are also release forms that a lot of times the debtor can sign off on so that the defendant's attorney can obtain those records. So tax information, authorization, Social Security Administration, consent and release forms for employment information, OSHA Form 960, which is the authorization for release of health information pursuant to HIPAA. So also the plaintiff's attorney and the plaintiff can request documents from the lender as well. So the loan records, copies of promissory notes, debtor's applications for deferment and forbearance, any correspondence between the borrower and the lender and servicer, and any documents related to the disbursement of the loan, including like financial aid records from the school. Okay, so I want to also touch on the treatment of student loans in Chapter 13. So Chapter 13 does have its advantages, right? So even if a student can't be discharged, oh, sorry, I skipped the slide. Even if a student can't be discharged based on undue hardship, the student can manage their payments through the Chapter 13 plan, right? So when the debtor files Chapter 13, their payment plan is based on their disposable income. So sometimes you have private student loans where the minimum payment could be like a mortgage payment. It's like over $1,000 a month. So I've seen upwards of $2,000 or $3,000 a month, right? So, but if based on their income, they can only afford $500 a month, that's what the monthly payment is going to be, and they're going to be able to manage it without having to worry about lawsuits and collection activity. Again, so to my second point, there's no collection action, garnishment, or tax interceptions that can happen against the debtor while they're in a Chapter 13. Again, student loans are treated as non-priority unsecured debts, so it's pretty low on the hierarchy of debt, right? So secured debt would be at the top, like your mortgage and your car note, and then priority debts like taxes, alimony and child support, things like that. And then the next thing is they can cure default. And the best part of Chapter 13, even when a debtor qualifies for a Chapter 7, sometimes it's necessary to protect their co-signers, especially when it's a toxic situation like an ex-spouse or an ex-boyfriend. So I've seen this where, let's say someone's boyfriend from college co-signed their private student loan and they've defaulted on it. And now, now that ex-boyfriend is getting calls and letters and their credit is taking a hit and they've become angry and, just combative with your client, with the debtor, the Chapter 13, even though the person's income is low enough and they have no assets and they would qualify for a 7, but the fact that there's a cosigner involved that needs to be protected would warrant filing a Chapter 13 instead. Okay, so again, just part of the statute that says the co-debtor that applies to the co-debtor stay. So that's section 1301, and it protects protects parents or other family members who may have co-signed the debtor's student loan, even if they do not seek bankruptcy. Like, even if the cosigner doesn't file bankruptcy, they still get the same protection as the borrower, and it protects them from all collection efforts. Okay. So one of the things that comes up for student loans in Chapter 13 is that the Chapter 13 unsecured debt is capped at $465,000, $465,275. So I know this sounds crazy, but a lot of student loans lately, especially for people who have grad school debt, is above that amount. Like, I have a client right now that I'm working with who has $800,000 of student loans.
Hold on. Because I'm looking at this number like capped at 465. How many people going
Yeah,
over?
so that's the cap for Chapter 13 unsecured debt, right?
Right. So this was like you.
So
So I just want to help our audience remember. You said there was 7 and there was 13, and there's this fictional 20. Would you just use it as a shorthand for when you file the 7 first, get all the discharge, and then file the 13 to do the adversary proceeding for the qualified student loans. But then sometimes just going straight to 13 is better. Like, for example, when you have a cosigner. And then now we're looking at this cap. But how do we get to, I know it's your client, but like what situation leads to people getting 800,000? Is it including the interest that's compiled?
Yeah, I've seen crazy numbers like that before. It really happens when the loan has not been paid in decades, right? So 20 years have gone by. And this particular client has like 2 degrees, so an MBA and a law degree. She didn't finish the MBA, or she started the MBA program, but it's like 20 years of accumulating debt and not paying, and the interest continues to mount. And that's how that happens. And the federal government allows it to happen because they kept lending her more money. So that's also part of the problem, which is why I said the system is really flawed. It's broken, and they want to leave the students holding the bag and take no responsibility for the part that they played in it. Does that make, you see what I'm saying? Like, it makes
Yeah,
no
so we're looking at not just the principal, but the accrued interest as well. This
right,
cap is on all of it. And then, of
right,
course, if you have credit cards and other things that also might not get paid and lots of interest and all that.
right. I mean, this is just her student loan debt is
Right.
$800,000.
Wow.
Right. So, yeah,
So so someone like that, their credit's already shot, but filing bankruptcy still can assist them because of all the things we just talked about.
exactly,
Okay.
exactly. So, so the courts are divided on whether someone with massive student loan debt above the cap can file under 13, because some courts are recognizing that student loan is not your regular unsecured debt. It should be treated differently, you know. All right, oops, hold on. Need to go to the next slide. Okay, so there's a separate classification of student loan debt in Chapter 13. So many courts have found that separate classification of student loan debt is fair because, it furthers the goal of getting a fresh start, and encouragement of student loan payment is important public policy. So during a Chapter 13, the debtor can stay current on their income-driven repayment plan, and they can make progress towards their public service loan forgiveness program and other loan forgiveness program, and they can maximize the payment towards a non-dischargeable debt. And they can also avoid accrual of post-petition interest. Okay, also, in Chapter 13, they can cure default on the long-term student loan debt. So It permits the Chapter 13 debtor to cure a default and maintain payments on long-term debts on which the final payment is due after the final payment of the plan. This definition clearly applies to any student loan with scheduled payments that will be due after the end of the Chapter 13 plan period. A cure in Chapter 13 bankruptcy pays ongoing scheduled installments as they come due on the long-term debt while simultaneously making monthly payments to pay back any pre-bankruptcy arrearage. The cure nullifies the contractual consequences of any pre-bankruptcy default and restores to the pre-default status quo. Okay, so also in the Chapter 13, the debtor has the opportunity to challenge the validity of the debt because the creditor is required to file what's called a proof of claim before getting paid. So the proof of claim form is used by the creditor to indicate the amount of the debt owed by the debtor on the date of the bankruptcy filing. And they have to provide documentation that shows that, like a signed promissory note, the agreement with everything that substantiates their claim. So a Chapter 13 debtor is an interested party with a right to object to a claim. So if they feel like the documentation is not valid, or sometimes the lender doesn't have the required documentations because it was sold off so many times that they lost the paperwork and they're not able to file a proof of claim. So then that means that they don't get a chance to collect and be part of the payment plan.
Will that mean it's also discharged because they
Yeah,
weren't able to?
exactly.
Wow. Yeah. So we
Yeah.
saw that a lot with foreclosures in Florida because I did foreclosure work when I first
Right,
graduated in
exactly.
2009. And a lot of the banks could not produce the paperwork. And people like, so
Right.
they just get to stay in the house. There's
Mm-hmm.
some different, things because there's some public records that are available to kind of establish it. But we got
Right.
to always remember you don't know who doesn't have this paperwork until you actually go forward with the case. So far, I'm
Exactly.
like, this sounded really hard, Natalie. You did this on your own. Go, girl. Right? Because
And
I've done
when I didn't
bankruptcy.
know what
So,
I was doing, but it's a good thing because if I had already been programmed the way bankruptcy attorneys have been programmed, especially back then, because I filed my case in 2013, I would have never been crazy enough to do it, right? Like, it's because I was an outsider that I was able to do it. And I always compare myself to Elle Woods in Legally Blonde.
yeah.
It's because she was not part of that world. She was like, oh, I'm going to Harvard. Like, what? Like, what's the big deal? Like, what do you guys, like, calm
Yeah,
down.
yeah. And I remember you
What? Like,
posting
it's
about
Harvard.
it when you were
Yeah,
going through it. And I'm like, oh,
exactly.
girl. Just, it was like David and Goliath. And I'm like, holy gosh, you won.
Exactly. Because I
Yeah.
really was just clueless and like new kid on the block, and I managed to figure it out. And I'm like, that's when I said, well, if I can do it, anyone can do it. And it's like, it's been over a decade, and the needle is moving so slow. Like, even after the new DOJ guidance was issued, it's going on 2 years now, that people are still not um really like pursuing it. Like, lawyers are not really letting their clients take advantage of this option, right? And there are many reasons for that, and I'll get into it a little bit when I go into the information about the new guidance. So let me
Okay.
get
So let's
into
do
that.
that. Yeah.
Okay, so the new guidance was issued on November 17th, 2022. And in the press release, they said the new process will leverage Department of Education data and a new borrower completed attestation form to assist the government in assessing the borrower's discharge request. The significance of the new guidance. So the current standard for discharge was random, arbitrary, and unfair, which is true. Like, after doing it for so many years, it was really all over the place, and it depended on who the adversary was, who the judge was. It's just really random. The litigation was often too costly for the debtor to afford, because litigating in federal court is not an easy task, right? So most clients are most attorneys who are even going to attempt this are going to charge a lot up front, where most people who qualify to get a discharge would not have that kind of money to pay an attorney. So it's just this, stuck between a rock and a hard place, right? So the new guidance seeks to rectify that by setting clear, transparent, and consistent expectations for discharge, reducing the burdens on debtors by simplifying the process and increasing the number of cases that the Department of Education can agree to support a discharge. So it's important to note that it's a policy change and it's not an amendment to a statute or rule. The adversary proceeding is still required. It's not a matter of filling out the form. The debtor still needs to file a complaint and go through the steps, filing the complaint, serving the summons and complaint on all the adversaries. And the guidance is for the Department of Justice and was developed by the Department of Justice in conjunction with the Department of Education. And the purpose of it is to, facilitate settlement and stipulating to a discharge. It does not create any rights, substantive or procedural, enforceable at law by any party. Okay, so it's important to note that the new guidance only applies to federal direct loans. So private loans are not included, and the other types of loans like FFEL loans are not included, although there was some guidance released afterwards that said the FFEL loans, those lenders they have the permission to use it, but they're not required to use it. So it only applies to debtors that are in an open bankruptcy case as of November 17th, 2022, or an adversary proceeding that was pending as of November 17th, 2022, and debtors in future bankruptcies. So old cases, although you can reopen the case to litigate the student loan debt, the new guidance would not apply to cases filed prior to this date. Okay, so the objectives are to assure access to justice, to provide clear eligibility requirements, to provide a more expeditious process, to reduce the cost of litigation for deserving bankruptcy debtors and the federal government. So it's just, and since the new guidance came out, it really has been a seamless process. And I haven't lost one yet since the new guidance came out for federal student loans. So the guideline applies in both Brunner and totality test jurisdictions. And basically they recognize that both of those tests are looking at the debtor's current and prospective financial situation in relation to the educational debt, and they came up with their own factors that they look at, which basically encompasses Brunner and the totality test. So we're looking at A, the present ability to pay, B, the future ability to pay, and C, good faith efforts. Okay, so the debtor's present ability to pay, if the debtor's expenses equal or exceed the debtor's income, the department will determine that the debtor lacks the present ability to pay. Similar to the bankruptcy court and laws, they use the IRS standards to determine what allowable expenses mean. So the national standards are the same as under the means test. The local standards, they're limited to their actual expenses rather than, the standard. So the standard only serves as a cap. And IRS other necessary expenses, and then reasonable expenses not yet incurred. So this is a really important change, the reasonable expenses not yet incurred, because so many debtors are foregoing things they need, like they're not able to move out of their family home or they're not able to afford proper childcare or proper medication for whatever conditions they have. So they're foregoing those necessary expenses. So the new DOJ guidelines permit them to add that to the budget, right? So the rent that they would be paying if they could afford to, right? If they could afford to move out, or the glaucoma medicine that they should be taking that their doctor prescribed to them, but they can't afford because they're literally just scraping by. So that becomes part of the analysis, which is a major game changer as well, like since the new guidance was released. So when they're looking at present ability to pay, they compare expenses to income. The debtor's gross income includes Social Security and unemployment. The assistant U.S. attorney should use the standard monthly payment amount, which is also a major change because prior to the new guidance being issued, the assistant U.S. attorney would always argue that, oh, the debtor qualifies for a zero payment, so how can they claim that a zero payment is a hardship? Um, how can they say they can't afford it? And of course, there was a lot of pushback and back and forth. Well, the zero payment is temporary because they have to recertify for 25 years. Meanwhile, they have a six-figure debt that continues to grow out of control. So how does that help? So now with the new guidance, it's very clear what the payment amount we're using. We're not using this imaginary zero payment. We're looking at what is the standard payment? And it's always an amount that clearly, obviously, does not fall into the debtor's budget. Also, just when looking at present ability to pay, partial discharge may be an option. Okay. So the factors that the court will look at for future ability to pay, and it's basically if any of these circumstances are present, there's a presumption that they lack the future ability to pay. If they're 65 or older, if they have a disability or chronic injury, if they've been unemployed for at least 5 of the last 10 years, if they failed to obtain the degree for which the loan was procured, and the payment status is other than in school for at least 10 years. So if they can check any of these boxes, then that second prong is satisfied. The presumptions are rebuttable. And again, you should claim all the presumptions that apply. And if a presumption does not apply, the debtor can attest to other facts that are relevant to their future ability to pay. Good faith efforts. So evidence of good faith includes making a payment, applying for a deferment or forbearance, applying for income-driven repayment, applying for a consolidation loan, responding to the outreach from a servicer or lender or collector, engaging meaningfully with the Department of Education and their servicer, and engaging meaningfully with a third party they believed would assist them in managing their debt. Because there are a lot of third-party companies that pop up. Most of them are not even legitimate, but if that debtor assumed or they really thought that this person or this company was helping them manage the debt, then if they can prove that is a demonstration of good faith. So other criteria includes efforts to obtain employment, maximize income, and minimize expenses, actual payment history, evidence that the debtor lacked financial means to pay should be considered, the income-driven repayment plan enrollment. Again, non-enrollment is non-controlling. Assistant U.S. attorney should accept any reasonable explanation of why the debtor's non-enrollment in an IDR plan. So filling out the attestation, I will also include in the materials for you guys a copy of the attestation form. And the form is basically, it's like 16 pages and it's submitted under oath. And the debtor signs under penalty of perjury, and they go over all of the like their financial information essentially. And we are, out of time, but I want to just go quickly through what the attestation form, uh, requires. So it looks at the personal information, the loan information, the household income and monthly expenses. And then again, when you're looking at the expenses, you're looking at local standards for housing, utilities, and transportation. And if the debtor's expenses are below the IRS standard, the assistant U.S. attorney will use actual expenses. Again, we're looking at other necessary expenses, alimony, child support, babysitting, daycare, and it's allowable if it's reasonable and necessary. Again, I touched on this, reasonable expenses not incurred. The government recognizes that people are foregoing what they really would need in their budget. Okay. If the bankruptcy is filed within 18 months of an adversary proceeding, schedules I and J can be used to establish their income and expenses. Okay. Again, I touched on this, the future inability to pay, the factors they look at, and prior efforts to repay, including efforts to obtain employment, maximize income, minimize expenses, and generally handle their finances. Section 5 looks at their current assets, including real estate, motor vehicles, retirement accounts, any interest in a business, and anticipated tax refund. No dispositive weight is given to non-liquid assets, and no dispositive weight to assets critical to debtor maintaining a minimal standard of living. For example, their house. And no weight given to exempt status of assets. And the last section is a catch-all for the debtor to make any additional arguments. And that's all I have. And this is just a list of resources that you can look to research the topic and find out more. Okay. And here's my contact information. Please, 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 if you have questions about any of the topics I touched on or bankruptcy in general, please feel free to reach out. Don't be shy. I really enjoy, talking about this and helping people navigate the student loan adversary proceeding process. So,
Thank you, Natalie. We can tell that you're passionate about this. We're
mhm,
gonna provide a copy of the a PDF of your presentation. So although we
okay.
went through some of those last slides pretty quick, you're gonna have time if you really want to dig in. Just gonna give us
Mhm,
the form as well. And I
okay.
think anybody who has student loans needs to be watching this, right? Not just lawyers. So I have two final questions for those who want to hang out and might have these questions as well. So if I'm thinking about doing this for myself, where do you recommend I start? As a someone with student loans. And on the second side, if we have some folks that's like, well, I want to add this to my practice, where would a lawyer who wants to begin doing this type of work start?
Right. I mean, since I'm talking to lawyers, I invite whether you're trying to do it for yourself or for a client, just to start, taking CLEs on the topic, right? And going to, I'm part of the National Association of Consumer Bankruptcy Attorneys. It's NACBA for short. They have a lot of resources on their website and they do a convention every year. So you can really talk to and get to know experts in the field. And there's really a handful of us in the whole country who are really well versed in student loan debt. But there's a lot of resources online. And I'll be honest, like in the beginning, when I was first doing this, yeah, I took some CLEs, but the real practical, like good stuff, I found a lot of it on YouTube. I know it sounds crazy, especially
No,
back
I live
then,
on YouTube. Yeah, so I know
but
there's good stuff
like
out there.
I found, and that's the company I found, and I don't even think it still exists. It's called pardonmydebt.com. They might have either got bought out or they closed down, but pardonmydebt.com, that's where I had signed up to have them help me with the forms or something. And then that's where I learned that, oh my gosh, there's a whole complaint here about student loans. Like, what? That's when
Yeah.
my mind was blown. Like I had read about the undue hardship exception in one of the like textbooks I was reading, but when I saw that complaint where it's like a sample, like plaintiff, defendant, and like it goes through the Brunner test, and I was like, my mind.
Yeah.
But anyway, the internet, oh my God. It's
Yeah.
I mean, and it's even better than it was when I started out. So can you
Exactly.
imagine what's out there now, you know?
Yeah. Yeah. You just got to be
Um,
careful because now there's so much you got to figure out
yeah, so you got to figure
what
out what's
works. Yeah.
legit. But
Yeah.
we're smart. We're attorneys. So we're able to like discern like what's, valid information and what's nonsense. So, yeah. So I mean, and again, also I'm happy to coach you through whether it's your own case or you're assisting a client. Um, you know, yeah, so I guess I hope that answers the question.
Yeah, reach out to Natalie. I didn't want
Yeah,
to volunteer you, but you
yeah,
just said it.
I know.
Call Natalie if you are interested in pursuing this because there's a lot of people who need you. Because
Mhm.
Florida now is like it's like New York. It's like $2,000-$3,000 rent now to get
Yeah,
apartments. And the cost
yeah,
of living is just skyrocketed, and the
yeah.
cost of attendance has skyrocketed. And so now we have people who, or didn't finish their degree, all this stuff, and they're just feeling very stuck. And hearing
Right,
what you heard, oh
right,
no, there's nothing you can do. You just have it. You're stuck with it for the rest of your life. No, you're not. And let's
right.
figure out a plan to at least see if we can reduce it. So thank you so much
Exactly.
for sharing that
Of
information.
course, my pleasure. And, like I said, I don't be shy. I am always happy to answer questions and be a resource for you, whether you want to get into this area. And I had a conversation with a trustee a few weeks ago. He said student loan dischargeability is going to be the bread and butter for bankruptcy attorneys in the future because everything else can be done with AI. Like people don't even need attorneys anymore, but this is the part that's complicated and nuanced. And if you are at all interested in bankruptcy, learning how to litigate student loans is going to be the key to really making it lucrative. So I invite you, if you are at all interested in bankruptcy, to really learn this and market it to your clients because it's so much easier than it used to be. It doesn't take years anymore to get a resolution. You can get a resolution in like 6 months. So,
Wow, that's the quote.
yeah.
That is the quote. Learn to litigate loan discharge,
Dischargeability.
student
Yeah.
loans discharge. All
Discharge.
right, girl. Thank you.
All right. You're welcome. Bye.